So done with the Fourth Bill of Rights, the Fourth Amendment, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. That's the Fourth Amendment. So now we'll transition and analyze the language in the Fourth Amendment. Okay. Law definition of affirmation. In practice, a solemn and formal declaration. A solemn and formal declaration or asseveration that an affidavit is true, that the witness will tell the truth, etc. This being substituted for an oath, or in certain cases, a solemn religious asseveration in the nature of an oath. So affirmation is dealing with the affidavit, which is true, and you affirm that is true. Continuing, Quakers as a class and other persons who have contentious scruples against taking an oath are allowed to make affirmation in any mode which they may declare to be binding upon their consciousness in confirmation of the truth of testimony which they are about to give. Case law to support. The law definition of affirmation of fact. Affirmation of fact. A statement concerning a subject matter of a transaction which might otherwise be only an expression of opinion, but which is affirmed as an existing fact material to the transaction and reasonably induces the other party to consider and rely upon it as a fact. Stone versus McCarty. Case law to support that. So when you're putting in any type of writs or affidavits, typically the title is going to say writ of discovery or affidavit of fact. So these are the principles. You're saying your truth is on paper. It's your truth. So dispute my truth in so many days. For example, law definition of oath. Any form or attestation by which a person signifies that he is bound in conscience to perform and act faithfully and truthfully. Bond versus State. An affirmation of truth of a statement which renders one willfully ascertaining untrue statements punishable for perjury. And then typically at the bottom of any affidavit, you're going to say something to the effect of, I solemnly swear, to the nation, in our case, the Moorish nation, pledging allegiance, and we swear that all this is true, to conclude the affidavit. And when you read the 10 maxims of law, you'll see that's one of the maxims, to put at the concluding your affidavit, pretty much solemnly swear that this is the truth and the whole truth, etc. Something to that effect. Continuing with the law definition of oath, an outward pledge by the person, taking it that his attestation or promise is made under an immediate sense of responsibility to God, moral versus state, a solemn appeal to the supreme being in the attestation of the truth of some statement. We're still dealing with oath. An external pledge or asseveration made in verification of statements made or to be made, coupled with an appeal to a sacred or venerated object in evidence of the serious and reverent state of mind of the party, or with the invocation to a supreme being to witness the words to the party and to visit him with punishment if they be false. So that sounds like that's a different realm right there. And we're still dealing with oath. But see the elements of it. Reverent state of mind, invocation to a supreme being. We know the etymology of God is to invoke. So let's let that sink in. Humble Bay Islam. Brother Alexander Gibbs, Islam, happy holy day.
Islam, happy holy day to the nobles was popping.
So we're still dealing with oath, law definition of oath. In its broadest sense, the term is used to include all forms of attestation by which a party signifies that he is bound in conscience to perform the act faithfully and truly. In a more restricted sense, it includes all those forms of attestation or promise which are not accompanied by an appreciation. The term has been variously defined as a solemn invocation of the vengeance of the deity upon the witness if he do not declare the whole truth so far as he knows it, or a religious asseveration by which a person renounces the mercy and appreciates the vengeance of heaven if he do not speak the truth, or as a religious act by which the party invokes God not only to witness the truth and sincerity of his promise, but also to avenge his imposture or violated faith, or in other words, to punish his perjury if he shall be guilty of it or be guilty of lying. So you pretty much putting it on everything you love, Allah, the heavens and the universe, anything that's binded to the Hermetic laws, the Hermetic principles. You know, you solemnly swear that what you're saying is the truth. Islam, Kamisha, happy holy day.
Islam,
He was going in and out, but I think we got the jets.
who, me?
Yeah, there you go. We hear you now. And
Okay, Islam, y'all.
Islam.
Happy holy day.
Okay. Continuing with the law definition of oath, the essential idea of an oath would seem to be, however, that of a recognition of God's authority by the party taking it and an undertaking to accomplish the transaction to which refers as required by his laws. So that was all the components of the law definition of oath. Law definition of probable cause. And by the way, we're analyzing the Fourth Amendment or the Fourth Bill of Rights and the lingo that was in the Fourth Amendment or the Fourth Bill of Rights. Probable cause, law definition of probable cause, having the appearance of truth, having the character of probability, appearing to be founded in reason or experience, state versus theli, having more evidence for than against, supported by evidence which inclines the mind to believe, but leaves some room for doubt, likely. Barron versus Green River, Sir Rock Springs Livestock Company. Apparently true, yet possibly false. Probable cause. Reasonable cause. Having more evidence for than against. A reasonable ground for belief in the existence of facts warranting the proceedings complained of. So as we cap off, well, not cap off, but we still got some more to read about probable cause. But one of the elements of probable cause, complained of. So that means a human being said you violated them or their property. You injured them, an actual human. Then, pop off the due process. So continuing with probable cause. An apparent state of facts found to exist upon the reasonable inquiry, that is, such inquiry as the given case renders convenient and proper, which would induce a reasonably intelligent and prudent man to believe in a criminal case that the accused person had committed the crime charged, or in a civil case that a cause of action existed. Case law to support. Still dealing with probable cause. In a malicious prosecution, the existence of such facts and circumstances as would excite the belief in a reasonable mind, acting on facts with knowledge of the prosecutor that the person charged was guilty of the crime for which he was prosecuted. Case law to support that. A reasonable ground of suspicion supported by circumstances sufficiently strong in themselves to warrant a prudent and cautious man to believe that the accused is guilty of the offense with which he is charged. Case law to support that. Such a state of facts and circumstances known to the prosecutor personally or by information from others as would, in the judgment of the court, lead a man of ordinary caution, acting conscientiously in the light of such facts or circumstances, to believe that the person charged is guilty. Where defendant in an action for malicious prosecution shows that before commencing the prosecution, he, in good faith, consulted an attorney for good standing and made a full disclosure of all the facts reasonably obtainable, and in good faith acted upon such advice, this of itself constitutes probable cause. Continuing with the law definition of probable cause, as justifying arrest without a warrant by one believed guilty of felony or to be engaged in a commission of a felony, is a belief fairly arising out of facts and circumstances known to the officer that a party is engaged in the commission of a crime. For search warrant means reasonable grounds of suspicion, supported by circumstances sufficiently strong to warrant cautious man in believing party is guilty of offense charged. For arrest, which must be shown as justification by defendants in actions for false imprisonment, is a reasonable ground of suspicion supported by circumstances sufficient in themselves to warrant cautious man in believing accused to be guilty, but does not depend on actual state of case in point of fact, as it may turn out upon legal investigation, but on knowledge of facts, which would be sufficient to induce reasonable belief in truth of accusation. Transitioning to the law definition of rights, because that was the language in the Fourth Amendment, the Fourth Bill of Rights. Rights, a noun, and taken in abstract sense, justice, ethical, correctness, or contents of the rules of laws or the principles of morals. In this signification, it answers to one meaning of the Latin jus, and serves to indicate law in the abstract, considered as the foundation of all rights, or the complex of underlying moral principles which impart the character of justice to all positive law, or give it an ethical content. As a noun and taken in a concrete sense, a power, privilege, faculty, or demand inherent in one person, and incident upon another. Rights are defined generally as powers of a free action, and the primal rights pertaining to men are undoubtedly enjoyed by human beings purely as such, being grounded in personality and existing incidentally to their recognition by positive law. But leaving the abstract moral sphere and giving to the term a juristic content, right, as well defined as a capacity residing in one man of controlling with the assent and assistance of the state the actions of others. So right, the assistance of the state, we should be clear what that means now. Assistance of the people that are organized. The noun substantive, a right, signifies that which juris, whoever doesn't know what juris mean, look that up. That which juris denominate a faculty, that which resides in a determined person by virtue of a given law, and which avails against a person or answers to a duty lying on a person other than the person in whom it resides. In the noun substantive, rights is the plural of the noun. Substantive, and look up substantive, because that's on most nationality cards. Substantive rights. Hope y'all know what that means. Substantive, a right. But the expression right, when it is used as an adjective, is equivalent to the adjective just, as the adverb rightly is equivalent to the adverb justly. And when used as the abstract name corresponding to the adjective right, the noun substantive right is synonymous with the noun substantive justice. This is all in the law definition of right. This is still dealing with that. In a narrower signification, an interest or title in an object of property, a just and legal claim to hold, use, or enjoy it, or to convey or donate it as he may please. The term right in civil society is defined to mean that which a man is entitled to have or to do or to receive from others within the limits prescribed by law. Right? Rights of indigenous people, treaties, etc., any type of trust documents, community trusts. That which one person ought to have or receive from another, it being withheld from him or not in his possession. In this sense, right has the force of claim and is properly expressed by the Latin jus. Lord Coke considers this to be the proper signification of the word, especially in writs, in pleadings, where an estate is turned to a right, as by discontinuance, decism, etc. Rights may be described as perfect or imperfect according to their action or scope is clear, settled, and determinate, or is vague and unfixed. So once again, rights may be described as perfect or imperfect according as their action or scope is clear, settled, indeterminate, or vague and unfixed. Rights are either in personam or in rem. A right in personam is one which imposes an obligation. So rights in personam is one which imposes an obligation on a definite person. A right in rem is one which imposes an obligation on persons generally, either on all the world or on all the world except certain determinate persons. Thus, if I am entitled to exclude all persons from a given piece of land, I have a right in rem in respect to that land. And if there are one or more persons, A, B, and C, who I am not entitled to exclude from it, my right is still a right in rem. Rights may also be described as either primary or secondary. Primary rights are those which can be created without reference to rights already existing. Secondary rights are those which can be created without reference. So let me run that back. Rights may also be described as either primary or secondary. Primary rights are those which can be created without reference to rights already existing. Secondary rights can only arise for the purpose of protecting or enforcing primary rights. They are either preventive, which is protective, or remedial, or reparative. Preventive or protective secondary rights exist in order to prevent the infringement or loss of primary rights. They are judicial. They require the assistance of a court of law for their encroachment, and extrajudicial when they are capable of being exercised by the party himself. Remedial or reparative secondary rights are also either judicial or extrajudicial. They may further be divided into 1, rights of restitution or restoration, which entitle the person injured to be replaced in his original position. 2, rights of enforcement, which entitle the person injured to the performance of an act by the person bound. And 3, rights of satisfaction or compensation. With respect to the ownership of external objects of property, rights may be classed as absolute and qualified. An absolute right to the person in whom it adheres the uncontrolled dominion over the object at all times and for all purposes. A qualified right gives the possessor a right to the object for certain purposes or under certain circumstances only, such as the right to a bailee to recover the article bailed when it has been unlawfully taken from him by a stranger. Rights are also either legal or equitable. The former is the case where the person seeking to enforce the right for his own benefit has the legal title and a remedy at law. The latter are such as for enforceable only in equity, as at the suit of Sestike Trust. Constitutional law. There is also a classification of rights with respect to the Constitution of Civil Society. Thus, according to Blackstone, the rights of persons considered in their natural capacities are of 2 sorts, absolute and relative. Absolute, which are such as appertain and belong to particular men, merely as individuals or single persons. Relative, which are incident to them as members of society and standing in various relations to each other. Rights are also classified in constitutional law as natural, civil, and political, to which there is sometimes added the class of personal rights. Natural rights are those which grow out of the nature of man and depend upon personality as distinguished from such as are created by law and depend on civilized society, or they are those which are plainly assured by natural law, or those which, by fair deduction from the present physical, moral, social, and religious characteristics of man, he must be invested with, and which he ought to have realized for him in a jural society. Look up jural society, is synonymous with body politic, and nation state. Or in order to fulfill the ends to which his nature calls him. Such are the rights of life, liberty, privacy, and good reputation. Good reputation, that's a right to have good reputation. That's why people sue for defamation of character. Civil rights are such as belong to every citizen of the state or country, or in a wider sense, to all its inhabitants, and share and are not connected with the organization or administration of government. They include the rights of property, marriage, protection by laws, freedom of contract. Freedom of contract, that would be Article 1, Section 8. There shall be no laws to get in the way of a valid contract. The contract is the law. So that's why trusts are important. Or as otherwise defined, civil rights are rights appertaining to a person in virtue of his citizenship in a state or community, rights capable of being enforced. That's the key. Rights capable of being enforced. Addressed in a civil action. Also a term applied to certain rights secured to citizens of the United States by the 13th and 14th Amendment of the Constitution and by the various acts of Congress made in pursuance thereof. So when you mention the 14th Amendment, now you're dealing with another type of citizenship and the rights that they have, which are, called privileges. So there's a different type of rights. Political rights consist in the power to participate directly or indirectly in the establishment or administration of government, such as the right of citizenship. So you see how it's interesting they have such as the right of citizenship after they say establishment, right? Let's rewind. Political rights consist in the power to participate directly or indirectly in the establishment or administration of government. So a citizen, once again, is an active member of their nation. They're part of the fold of administration, directly or indirectly. They're part of the momentum. They're not just spectating, looking around. They're actively part of the body. Such as the right of citizenship, that of suffrage, which is the right to vote, the right to hold public office, and the right to petition. Personal rights is a term of rather vague import, but generally it may be said to mean the right of personal security, comprising those of life, limb, body, health, reputation, and the right of personal liberty. As an adjective, a right means just, morally correct, consonant with the ethical principles or rules of positive law. It is the opposite of wrong, unjust, and illegal. In Old English, the term denoted an accusation or charge of a crime. Other compound and descriptive terms. base right. In Scottish law, a subordinate right, the right of a vassal in the lands held by him. Transitioning to the law definition of secure, because that was one of the elements of the Fourth Amendment or the Fourth Bill of Rights, right to be secure in your persons. Law definition of secure, to give security, to assure of payment, performance, or indemnity, to guarantee or make certain the payment of a debt or discharge of an obligation, case law. One secures his creditor by giving him a lien, mortgage, pledge, or other security to be used in case the debtor fails to make payment. Also, not exposed to danger, safe, strong, stable, or firm as to ensure safety. So it's different vantage points and lenses of scope dealing with secure. Law definition of seizures, because that was the language in the Fourth Amendment. That was the language in the Fourth Bill of Rights. Your right not to be searched without a warrant. No searches and seizures. Seizures, to take possession of forcibly, to grasp, to snatch, or to put in possession. Case law, Hardy versus State. The law of copyholds. Seizure is where the lord of copyhold lands take possession of them in default of a tenant. It is either seizure, quasi or absolute seizure. Practice. The act performed by an officer of the law under the authority and exigence of a writ in taking into custody of the law the property, real or personal, or a person against whom the judgment of a competent court has passed, condemning him to pay a certain sum of money in order that such property may be sold by authority and due course of law to satisfy the judgment, or the act of taking possession of goods in consequence of a violation of public law, case law. Seizure, even though hostile, is not necessarily capture, though such is in its usual and probable result the ultimate act or adjudication of the state by which the seizure has been made assigns the proper and conclusive quality and denomination to the original proceeding. A condemnation asserts a capture ab initio. An award or restitution pronounces upon the act as having been not a valid act of capture, but an act of temporary seizure only. Transitioning to the law definition of unreasonable. Once again, that was the language in the Fourth Bill of Rights, the Fourth Amendment. Unreasonable, irrational, foolish, unwise, absurd, silly, preposterous, senseless, stupid. Case law to support. Capricious, arbitrary, confiscatory. Transitioning to the law definition of violation. A violation or violated. Injury, infringement, breach of right. So when you hear the language shall not be infringed, now you're saying shall not be injured. Rights shall not be breached. Enacts that any person who shall violate the king's companion shall be guilty of high treason. Law definition of warrants. In contracts, and once again, that was the language in the Fourth Amendment, warrants. In contracts, to engage or promise that a certain fact or state of facts in relation to the subject matter is or shall be as it is represented to be. In conveyancing to assure the title to property sold by an express covenant or agreement to that effect in the deed of conveyance, to stipulate by an express covenant or an express agreement or express contract that the title of a grantee shall be good and his possession undisturbed. Law definition of warrant in a singular sense. A writ or precept from a competent authority. A writ or a precept from a competent authority in pursuance of law, directing the doing of an act and addressing to an officer or person competent to do the act and affording him protection from damage if he does it. Particularly, a writ or precept issued by the magistrate justice or other competent authority, addressed to a sheriff, constable, or other officer, requiring him to arrest the body of a person therein named and bring him before the magistrate or court to answer or to be examined, touching some offense which he is charged with having committed. So you see constable and other officer, back to the participation of the people. If it was 1,000, I like saying 100 just for functional and administrative and in-house funds would be secure. But if we had like 1,000 physical people, constables, I don't know if you know what constables are, but elected officials, and we call them muftis. You know what I mean? Officers, security. You can start arresting people for violations on the land, or at least in the jurisdiction that's created from the particular body politic. But that's that's another level. But this is how all nation states are operating. China, Japan, Korea, that's how they getting down. They're protecting their people by any means. Allegiance. So still dealing with warrant. An order by which the drawer authorizes one person to pay a particular sum of money. An authority issued to a collector of taxes, empowering him to collect the taxes extended on the assessment roll and to make distress and sell goods or land in the default of payment. So that would be equivalent to like a W-4. The W-4 warrants them to take money out of your check. That's just an example. Still dealing with warrant. A command of a council, board, or official whose duty it is to pass upon the validity and determine the amount of a claim against the municipality to the treasurer to pay money out of any funds in the municipal treasury, which are or may become available for the purpose specified to a designated person whose claim thereof has been duly adjusted and allowed. So that's how it's supposed to work. You sue the city, they got a treasury in-house. They got board members in-house. Slush funds and all that. That's how it's supposed to work. Still dealing with warrant. A warrant differs from a bond in that a bond is a negotiable instrument, whereas a warrant is non-negotiable and is subject to all times to the defenses it would be were it in the hands of the original payee, which is not the case with a negotiable bond. In England, a divided warrant or coupon, see coupons. Coupons, interest, and dividend certificates. Also, those parts of commercial instrument which are to be cut and which are evidence of something connected with the contract mentioned in the instrument. They are generally attached to certificates of loan where the interest is payable at a particular periods, and when the interest is paid, they are cut off and delivered to the payer. In England, they are known as warrants or dividend warrants, and the securities to which they belong. Coupons are written contracts for the payment of a definite sum of money on a given day, and being drawn and executed in a form and mode for the purpose that they may be separated from the bonds and other instruments to which they are usually attached. It is held that they are negotiable and that a suit may be maintained on them without the necessity of producing the bonds. Each matured coupon upon the negotiable bond is a separable promise, distinct from the promises to pay the bonds or the other coupons, and gives rise to a separate cause of action. And once again, as we near the conclusion of analysis of the Fourth Amendment, these are questions we all need to ask ourselves. If we know, and be honest with yourself. How does the Fourth Bill of Rights Amendment secure? Question 2. What of the people is secured in the Fourth Amendment? Question 3. What are the people secured against? Question 4. What must first be obtained in order to pass the Fourth Bill of Rights? And give an example. Number 6. Who cannot utilize the Fourth Bill of Rights and why? Question 7. If they use the Fourth Bill of Rights is used against the people, what is that called? Question number 8. What must be described in the warrant? Question number 9. When must the warrant be obtained? Group discussion question. The purpose of the Fourth Bill of Rights is to secure people from who? And overall assure them of what? So this will be the concluding of this segment. I'm gonna go ahead and stop the recording. And I would love to have a group discussion on what was read right now.